Thank you so much, Iram. Honorable Justice Dhulia, Honorable Justice Bhat, my esteemed fellow panelists, ladies and gentlemen, a very good evening to all of you. Now, Tejas has covered quite a few important aspects. As I see it, and from the perspective of investment arbitrations also, there are various changes in law and business practices that arbitration practitioners must accept and get accustomed to. To name a few, litigation funding, the funding mechanisms that we all talk of these days. Now, litigation costs can be quite daunting for a company as its capital, productivity are all EBITDA are all negatively impacted. And litigation funding can help companies to use their capital to a more productive use, capacity development, product development, etc., rather than locking their capital to fund expensive litigation. Singapore now has a legalized framework in the form of civil law, third party funding rules, where domestic arbitrations, certain proceedings arising out of the Singapore International Commercial Court and related mediation proceedings are covered. Likewise, Hong Kong also has a legalized third party funding mechanism. And we should also look at something similar to that. Then, use of technology is something that arbitration practitioners must be readily willing to adapt to. Procedures like e-discovery and document management must be learned. There is recently a growing trend towards incorporation of AI and machine learning systems for predicting case outcomes and automating document review. Lawyers, legal professionals, students must learn these technologies to capitalize on their benefits and also to see if there are any pitfalls and to mitigate any risks. Then ESG expertise. Arbitration practitioners, I feel, should develop a deep understanding of the ESG principles and the impact that they have over dispute resolution, including any impact on damages, enforcement, liability, etc. And as the ESG disputes become more prevalent, it is important that as lawyers we learn those specialized procedures such as those provided by the United Nations Framework Convention on Climate Change and other international bodies. Then I also feel that we need a more need more gender diversity in our arbitral tribunals. Of course, Iram. And a commitment towards a more diverse pool of arbitrators, something that I strongly advocate.
Yes. Thank you so much. So you elaborated what Mr. Friedrich has said, users, innovativeness and mindset and environment. So you have covered everything, in a detailed manner. So with this, since it is very clear that now these two kind of disputes are very, very, very different from each other, and we have different rules, different game altogether. So, Siddharth, this puts me a question like how the arbitrability rules work here. So, is it that arbitrability sense is different from the sense we take arbitrability in the commercial arbitration disputes?
Yeah, Viram. So arbitrability has always been a problem, but broadly, the disputes which fall within the ambit of investment arbitrations are those which must come within the ambit of the bilateral investment treaties or any other multilateral investment agreement. Generally, the kinds of disputes which may arise between an investor and a host state pertain to their disagreements regarding interpretation of their respective rights and obligations under the investment agreement. The scopes may vary from the very broad all disputes concerning investments to a narrow specified kind of disputes only. And there are limitations also, because all these aspects must be kept in mind when we are looking at what is arbitrable, what is not arbitrable. Speaking of limitations, and as Justice Bhat also pointed out in the initial response to that query, in principle, an investment arbitral tribunal does not have jurisdiction over a purely contractual dispute, because a breach of a contract does not per se trigger a breach of treaty protection. Now, some investment treaties also have restrictions in the sense of preconditions or negotiation periods, without which you can't really refer the dispute to the investment arbitration. Some investment treaties may also provide that disputes cannot be brought on the aspect of security of a state, or there are certain general exceptions regarding recognizing the right of host state to regulate environment, health, safety. Arbitrability, we all know, means whether a dispute is capable of being resolved by arbitration. And in investment arbitration, scholars distinguish between subjective arbitrability and objective arbitrability. There are investment treaties which provide that nationality of an investor matters and the ownership structure of the investment matters. And if an investor is not able to meet that eligibility criteria, he may not be able to bring that dispute. And therefore, when scholars speak of subjective arbitrability, they say it's something which pertains to an entity or an individual who is not able to bring a dispute by virtue of its status or function. Objective arbitrability focuses on the subject matter. There are leading scholars who say that in investment arbitrations, both these aspects must supplement each other. But then a question often arises as to how do you determine arbitrability in investment arbitrations? Now, in determining the question whether an aspect is arbitrable, arbitration practitioners must look at the national law and the international law depending upon the time and the phase during which this question arises. ICSID note says that arbitrability must be determined by reference to the law governing the arbitration clause or the arbitration agreement. However, there are different tribunals which have opted for different approaches when resolving this question, and that leads to different solutions. ICSID, in fact, does not talk about arbitrability. What it provides is that parties may exclude certain matters from the jurisdiction of the tribunal, and therefore it uses a more generic expression, jurisdiction, rather than arbitrability. But arbitrability, like a burning issue in commercial arbitrations, it is also an issue for investment arbitrations and an ongoing discussion.
So that means, if we understand correctly, so there is no specific rule of arbitrability in the investment, and it differs, it varies from case to case and treaty to treaty.
That's right.
Okay, thank you so much. So with this now, Sidharth, quickly I'm coming to you that, since you are also into this practice and you are dealing with such kind of disputes, so according to you, and what is your experience that, what kind of challenges and opportunities do we have in such kind of enforcement, cases?
Yes. So when we look at the challenges, I'll start with the ICSID convention, which deals with the aspect of enforcement of investment awards. And Article 54 obliges all contracting states to recognize and enforce such awards as binding as if they are final judgments from those contracting states. India, however, is not a party to the ICSID convention. And therefore, India, unfortunately, is deprived of a regime which makes ICSID awards automatically enforceable. India has also availed the commercial reservation under the New York Convention, and the result of that is that only those awards can be enforced which are recognized as arising out of relationships which are considered commercial under the Indian law. Then there is also uncertainty over enforcement by courts in some situations, and rightly so, because courts have held that awards do not satisfy the test of commercial as required under the New York Convention for enforcement under the Arbitration and Conciliation Act. Another challenge which plagues the system is the option in certain situations given to host states to pursue multiple proceedings which run parallel to the enforcement regime. And this all affects the confidence of the investors. But there are opportunities also. There is good news also. Avnit is sitting, and the model BIT of 2015, in fact, now makes a provision, and I believe it's Article 27.5. I'll read that out to you, which provides that a claim that is submitted to arbitration under this article shall be considered to arise out of a commercial relationship or transaction for the purposes of Article 1 of the New York Convention. So what it means is that claims which are submitted to arbitration under the model BIT would be treated as commercial. and therefore enforcement becomes easy. But these are the challenges. But having seen the challenges, there are aspects which the investors can consider to enhance enforceability. Some of these I will quickly list out for the benefit of the audience. Diplomatic protections when investment treaties are being negotiated. There can be a requirement to include provisions concerning diplomatic protection, which mandate that a host state which is not giving recognition and which is not enforcing an adverse award, parties may resort to diplomatic protections. Then a prudent investor will always do something known as an asset tracing, will trace the assets in the host state, choosing the right arbitral institutions, because a right arbitral institution and rules will contain mechanisms for enforcement, so there will be certainty in that light. Choosing the right arbitrators and encouraging inclusion of effective dispute resolution mechanisms in the treaties itself, engaging in diplomacy, opting for political risk insurance that enhances arbitrability, staying informed about political and economic conditions of the host state, and lastly and most importantly, taking opinions from arbitration practitioners, consultants, valuation professionals who can then guide investors regarding the strategies to enhance arbitrability.
So you are paving your way. Okay. So